So hello and welcome to today's HRHuddle webinar on managing employees with depression and or anxiety in the workplace with Keeley Baigent of KSAB Law. Interestingly, Vanilla ran a poll on LinkedIn last month asking people how they were feeling about lockdown restrictions easing, and with lots of businesses planning on going back into their offices if they haven't already. The results were really interesting. 54% said they couldn't wait to get back into the office, which is wonderful. 23 said they felt stressed and anxious about it. 23 said they felt pressured. So it's a hot topic today, and we're going to explore whether depression and anxiety conditions could amount to disability in law, and if so, how we can how to manage the employees both as they return to on-site working or whether they continue to work from home. So the session today will be recorded like normal and sent to you in the next week. Please feel free to ask questions as we're going along in the chat box, and there's time for a live Q&A session at the end with Keeley. So feel free to ask as many questions as you want to. But Keeley, it's great to have you back with us. Thank you very much for joining us again.
No, thank you. And hello, everyone. So as Eloise said, the hot topic at the moment is definitely, or appears to be, dealing with employees who are suffering with anxiety and depression. And as we know, the isolation of working from home and the other lockdown measures have had a negative impact on a lot of employees and created or resulted in them suffering with the conditions, mental health conditions like anxiety and depression, or alternatively worsening those pre-existing conditions. There is evidence to suggest that during lockdown and while employees have been working from home, they have been working for longer hours. And whether that resulted from those employees picking up the additional work from furloughed colleagues, or because there's less travel time or no travel time, or alternatively because there's no divide anymore, it seems, between working time and personal time. Whatever the reason, it does seem that the evidence suggests that employees are working longer hours and that is having an impact on their health. So in this HRHuddle, we've had quite a few questions from various people about this topic, which I'm going to work through. So Eloise is going to pose those questions, which I'll answer. And during that, we'll be exploring whether the mental health conditions such as anxiety and depression could amount to a disability in law, and in particular under the Equality Act, and if so, how to manage those employees suffering with those conditions as they continue to work from home and as they begin to return to the office. So I'm ready for the first question, Eloise.
Okay, great. So we'll start with the big one. Can anxiety or depression amount to a disability?
Yeah, okay, so we need to look at, for this, the definition of disability that appears in the Equality Act. So let's have a look at it. There it is, Section 6 of the Equality Act. A person has a disability, or an employee has a disability, if they have a physical or mental impairment, and the impairment has a substantial and long-term adverse effect on their ability to carry out day-to-day activities. So that definition in itself poses 4 questions, and those 4 questions may well overlap to a certain degree, but a tribunal dealing with those questions will work through them in that way, methodically. And so it's useful for us to do that as well in trying to determine whether or not the condition which the employee is suffering with does amount to a disability in law. So dealing then with the first question, and we're looking at depression and anxiety in particular. Those are mental health impairments or mental impairments. They're not physical impairments. They may have a physical impact on an employee, but they are mental impairments. Moving then on to the second question of whether the mental impairment of anxiety or depression has an adverse effect on the employee's ability to carry out day-to-day activities. So we are looking at day-to-day activities. This is not simply looking at what the employee does in the workplace. The assessment is whether or not they are suffering to conduct day-to-day activities and their impairment is impacting on those. So the Equality Act guidance provides confirmation of what normal day-to-day activities may consist of. And it states, in general, day-to-day activities are things people do on a regular or daily basis. And examples include shopping, reading and writing, having a conversation, or using the telephone, watching television, getting washed and dressed, preparing and eating food, carrying out household tasks, walking and travelling by various forms of transport, and taking part in social activities. So that's quite useful. So what we need to do is apply our minds in respect of individual employees to the question of, can they conduct or is their impairment affecting them conducting day-to-day activities? According to the guidance, normal day-to-day activities does not include activities which are normally only conducted for a particular person or small group of people. So we're looking at a large group of people conducting those activities. In the area of anxiety and depression, the normal day-to-day activities that might be adversely affected are things like reading, sleeping is a big one, communicating, of course, socialising, going out, albeit obviously that's been impacted by guidance, by COVID guidelines, socialising, going out, getting up in the morning, washing and dressing, planning for the day ahead, and organising oneself or organising one's day. Moving then on to the third question in respect of the disability definition that needs to be considered. It's whether the adverse effect on day-to-day activities is substantial. So in order for the mental impairment of anxiety and depression to amount to a disability, the day-to-day activities will need to be substantially adversely affected. So it's no good if they are impacted but mildly, they have to be substantially affected. And the definition of substantial is more than trivial or minor. So if a GP describes the symptoms for the employee of anxiety and depression as mild, then that may not qualify to satisfy the definition of disability. The focus should actually be on what the employee can't do rather than what they can do. So that's important to note as well. The guidance confirms that the effect of an impairment on more than one activity taken together could result in an overall substantial adverse effect. So we don't just need to home in on one activity. We can look at all the activities that are adversely, substantially affected. So the following example is given in the guidance, which is actually quite helpful. A man with depression experiences a range of symptoms that include a loss of energy and motivation that makes even the simplest of tasks or decisions seem quite difficult. He finds it difficult to get up in the morning, get washed and dressed, and prepare breakfast. He is forgetful and cannot plan ahead. As a result, he is often run out of food before he thinks of going shopping again. Household tasks are frequently left undone or take much longer to complete than normal. His house is a mess. Together, the effects amount to the impairment having a substantial adverse effect on him conducting day-to-day activities. So I think that is really helpful. So, that description there does emphasise and illustrate the substantial adverse effect on day-to-day activities. So it's those kind of questions really that you need to have in the back of your mind when communicating with an employee about their mental health. And there's no reason why you can't ask them those questions. What is affected by your health at the moment? Tell me what you can't do on a day-to-day basis. It's really important to note that what we have to do is we have to discount any medical treatment that the employee is receiving. And that includes both medication as well as such things like counselling, in order to determine whether or not the impairment has a substantial adverse effect on the ability to conduct day-to-day activities. So if the employee is taking medications such as Prozac for depression or citralopam for anxiety, then it is likely that without that medication, their impairment will have a substantial adverse effect on their ability to conduct day-to-day activities. Because if they are taking that kind of medication, then it's likely that the GP has assessed that they need that medication and it is impacting adversely and substantially on their ability to conduct day-to-day activities. And finally then, the fourth question in respect of the definition requires the substantial adverse effect on day-to-day activities to be long-term. So this means that the substantial adverse effect on day-to-day activities of the mental impairment of anxiety or depression must have lasted for at least 12 months or is likely to last at least 12 months or for the rest of the employee's life. And that is assessed at the time of the alleged discrimination. So we're doing it at the time we're talking to the employee about what we can do to assist them. So that is the assessment we're trying to make. And it's very difficult for us to make that. So hence the reason why I'm going to go on to indicate the need and illustrate the need for medical advice at this stage, at this early stage. But what we can do, of course, is assess when speaking with the employee how long they have already been suffering with those symptoms. It's also worth mentioning that 2 consecutive impairments can be aggregated for the purposes of determining the duration of an impairment, provided that they are related. So, for example, a man experienced an anxiety disorder. This had a substantial adverse effect on his ability to make social contacts and to visit particular places. The disorder lasted for 8 months, and then it developed into depression, which had the effect that he was no longer able to leave his house or go to work. The depression continued for 5 months. As the total period over which the adverse effects lasted was in excess of 12 months, the long-term element of the definition of disability was satisfied. So that's quite interesting as well, because it is very common for the condition of anxiety to progress or change to depression, or it could be stated on a GP certificate that the employee is suffering with both impairments at the same time. Okay, I'm ready for the next question now, Eloise.
Okay, lovely. When will an employer be considered to have the knowledge of an employee suffering with a mental health disability like anxiety or depression?
Yeah, okay, so this is key in that if an employer doesn't have knowledge of a disability, and that's actual knowledge, but it's also implied knowledge or constructed knowledge, so should the employer have known. So if the employer doesn't have actual or implied knowledge of a disability, then any claim for disability discrimination will not succeed. So hence the reason why we need to talk about knowledge. So an employer may have actually been told by the actual employee that they're suffering with symptoms of anxiety or depression. It may be detailed on the employee's self-certification note, or alternatively, the GP may have detailed this on the employee's fit note on the certificate provided by the GP. So that's pretty clear. We will have had knowledge, therefore, of the impairment of depression or anxiety in those circumstances. In other circumstances, the situation isn't going to be as clear. An employer may be faced with a situation where an employee has said that they're suffering with stress. So that isn't anxiety or depression. They say, I'm suffering with stress. Stress is not a mental impairment. It is a reaction to a circumstance or factual situation. Saying that, stress can progress to the mental impairment of anxiety or depression or something else. And therefore, if an employee or the employee's GP is saying the employee is suffering with stress, then it's still got to be taken seriously because of the risk that it progresses to a mental impairment that could end up then being a disability. So it's key at this stage for an employer to investigate the reasons that are causing the stress for the employee and to determine whether or not the reasons relate to a work situation. Now, if it does relate to a work situation, then it's important for the employer to work with the employee to try and alleviate or reduce the stress factors. There's a really useful questionnaire actually on the Health and Safety Executive's website that you may find helpful in working with an employee. And if you can work with an employee using the risk assessment, you can discuss with them what stress factors they're experiencing in their work. And then make a note of what can be done to reduce those stress factors and in what time scale. So it's quite a good tool to use if an employee is saying their work situation is causing them stress. The link's on the slide. Again, a less straightforward situation might be that the employee is suffering with a number of ailments or giving a number of reasons for intermittent sickness absence. And if that's the case, then there might be a risk that actually the employee is suffering from an underlying mental health impairment, like anxiety or depression. So they may be saying, I can't sleep, I haven't come into work today because I can't sleep, or they may be saying, I've got a headache, or they may be saying generally they're fatigued. And those sorts of things you need to be potentially live about, because you need to be thinking, well, actually, this is happening quite a lot here. Is there an underlying mental health condition that we potentially could be we could be accused of knowing about impliedly or constructively? So those kind of situations need to be investigated as well through discussion with the employee.
Keeley, what if I'm just thinking about a different situation. What if an employer doesn't have a sick note or fit note or anything like that, but an employee talks to a colleague, one of their peers, and says that they're suffering with anxiety or depression? They don't speak to HR or they don't speak to their line manager. Would then the employer or HR still be expected to know because they've spoken to one of their colleagues in the workplace?
I think it depends on the level of the colleague. So if they are speaking with somebody in a managerial position, whether that's supervisor, line manager, then I think that at that point the employer could be accused of having actual knowledge of the disability. So I do think it depends on the level of the employee, the colleague that they're speaking with. But I think it leads on to the need for general training in this area of mental health, which I know you have dealt with in previous HRHuddles. So I think it's key to be training staff, making staff aware that employees are aware that some employees are suffering with mental health issues as a result of lockdown measures. and urging employees to speak with appropriate management if they are concerned about their own health or another colleague's health, and that can be done on a confidential basis.
Okay, great, thank you. So what issues could arise in respect of an employee suffering with anxiety or depression?
So the issues we're going to be experiencing potentially in respect of an employee who is suffering with mental health impairment like anxiety or depression are things like long-term sickness absence. That's the obvious one. But also a high level of intermittent, short-term sickness absence. So a day here, a day there, a couple of days here, a couple of days there. And that might be for different reasons, or it might be for reported anxiety or depression. Saying that, there's evidence that through the pandemic and people working from home, there has been a reduction in absenteeism level by employees. They're not reporting that they are unfit for work. Now, whether that's because they're not needing to travel into work, so if they've only got to make it from their beds to the desk, they feel that they can manage that and push themselves through a day at the screen rather than actually getting on the bus or driving into work. And if they were doing that, they would probably determine themselves as unfit to do that. So I think that is the reason that, because there is no need to actually properly get dressed if you've not got a virtual meeting or travel into work, employees are thinking, well, actually, I don't feel great today, but I can push myself through it and do some work. So I think that's probably the reason why absenteeism levels have decreased generally. But of course, that then is having a potential impact on mental health issues, and it's having an impact on productivity levels or performance levels. So what employees are seeing more commonly at the moment is not an increase in absenteeism levels, but a decrease in performance, which is actually being caused by the mental health issues, which becomes more difficult to deal with because, of course, if and as people are working more remotely, it's less obvious. And it takes longer to pick up on these things and determine them. So that's the common one we're seeing. The issues arising from these mental health issues are that employees may be working longer hours, but their productivity levels are decreasing.
Okay, great. So if an employer has been told by the employee that they are suffering with anxiety or depression, or the employer suspects that this is the case, what steps should we be taking?
Okay, so the first one is communication. So we need to discuss the situation with the employee. This will be an informal investigatory meeting to determine or to discuss the issues that we have identified, whether that is an increase in intermittent sickness absence or whether that is an identified decrease in performance. And we need to have a general discussion with the employee to talk to them about the reasons behind this and to ask them generally about their health. Now, we may decide as employers after that meeting that we don't really do anything perhaps for a couple of weeks and we just need to monitor the situation. We may have signposted the employee to some helpful resources, and we may have spoken with the employee about generally improving their performance, structuring their day, and giving them reasonable pointers and advice in how to do that. However, if we believe either after the 2-week period or immediately that things need to be dealt with and this is quite serious and the employee's health and safety is a concern to us, then what we need to do is we need to say to the employee, we think it would be helpful from both your point of view as well as ours if you go and see an occupational health expert. We're saying we're informing the employee that we think it's going to be beneficial both for them as well as us. We need to state the purpose of that. And the purpose is that we're not medical experts, but we think we need to obtain medical information about the employee's health and about how any impairment or any health condition that they're suffering with is impacting on either their attendance level or performance level or both. And the purpose is for us to be able to work with that occupational health expert and the employee in order to provide any adjustments that may be needed to the employee's work pattern, their work environment, or their work situation generally to try and improve things. So it's beneficial, as I say, for both parties.
Keeley?
Yes.
Question. You referenced the fact that, you know, that initial conversation is informal.
It is.
Is it recommended that that's recorded in some way, shape or form on the individual's personnel file, or maybe further to our conversation today, email, just to cover off the key points? Because without that, you sometimes leave yourself a little bit exposed without having something to reference.
Yeah, exactly. So after that meeting, you will be writing to the employee to confirm what was discussed and confirm your desire to obtain a report from an occupational health expert detailing the reasons that you have indicated that you wish to do that. So exactly right. You need to record what was discussed in writing to the employee after that meeting. And yes, it can be recorded in the personnel file. Obviously, down when and if a procedure is commenced or concluded, we need to then consider from a GDPR point of view whether or not we need to retain that on the personnel file. But for now, yes, it can go on. So
sorry, one other point on that then. So if we're having an informal conversation with somebody because we have I suppose whether we have some kind of suspicion that person is not well, and the individual's not really open to the conversation, we've flagged something up that the individual may not want to go into to discuss, and only maybe then later that issue that they're suffering with mental health comes up at a later date.
Yeah.
That, I've certainly experienced that where you've recognised that there might be an issue. The individual has not, given any indication that there is an issue, and then raise it as an issue later on down the line to say that we've actually not done anything to support the individual. So it's a bit of a double-edged sword, really.
Yes, it is. But if you have got suspicion, there's an argument you've got implied knowledge. Yeah. Now, if the employee is denying any mental health issues, then that goes in your favour. But ultimately, if you are doing your utmost to try and get the employee to see occupational health or provide support to the employee and provide as much support and adjustments as you possibly can, then again, even if the employee is in complete denial or doesn't want to communicate their condition to you, then I don't think you can be criticised for that.
As long as we've got some reference to that, that initial conversation that we've raised our concern.
Yeah, definitely, exactly right. Yeah. So we write to the employee. We confirm what was discussed. If they are denying any issues, then that goes in the letter as well. But ultimately, the aim is to try and get them to see occupational health. So with the, just to say, so the reason why I'm suggesting occupational health and not the employee's treating GP or their treating consultant, if it's that serious, is because occupational health experts will be independent. They're not the the treating GP or the treating expert. So we're expecting that any report is more objective. Also, occupational health experts will be experienced in dealing with workplace issues and the impact of health conditions on employees' work duties generally. So that's the reason why we're going down the occupational health route rather than obtaining a report from a GP. They tend to be far more reliable. I'm not saying a report will give you all the answers, because it probably won't, but I think you can guarantee that you'll get a better report from an occupational health expert than you will from an employee's treating GP. So the next thing then to do is to instruct the occupational health expert. In the letter or the communication to the expert, we'll need to confirm to the expert exactly what the issues are. So whether that's increase in intermittent sickness level absence, long-term sickness level absence, or performance or productivity issues, that will need to be detailed in the letter. We will need to pose relevant and pertinent questions to the expert, and the questions are so important for us to be able to get reliable answers and responses and information we need to be able to make informed decisions about the employee's continuing employment and their ability to undertake their role. So I can't emphasize enough the importance of asking the right questions. So with the questions, because the questions will be around, potentially, if it's relating to performance, the employee's ability to perform their role, I would always suggest that you include a detailed job description or list of tasks that the employee is being expected to conduct in their role. And there is not enough detail that can go into that list. So, you know, it's things like, with anxiety, it's things like dealing with a certain number of emails on any one day from clients or internally. And on top of that, what are their other jobs? Because if an employee is suffering with anxiety, they will probably say that they find it very difficult to manage incoming emails on top of work that they're trying to do on a daily basis. So, as I say, it's really important that we get the list of tasks and job description as detailed as possible and the questions right when we send them to the occupational health expert to obtain their view. Right, so what? Sorry, go ahead. Sorry,
I was going to say, I've got a couple of questions.
Yeah.
If you're about to go on to the next thing. So, what if an employee refuses to go to an occupational health specialist?
That's what I'm going to cover now.
Oh.
Right. Okay. So we've asked the employee to go. They either refuse or they fail to attend the appointment. So first thing to do is check your contract. There should be a clause within the contract which says that the employer has the right to request an employee to attend an appointment with an appointed expert. So check your contracts to see if that clause is present. If it is, that clause should be referred to when you're writing to the employee to request that they go and see an occupational health expert. If they then fail to attend that appointment or refuse to go, then we can assert it's a breach of contract and we can deal with that in that way. Usually there's a cancellation charge if an employee fails to give sufficient notice of attending an appointment with an occupational health expert. What an employer can do is write to an employee prior to the appointment and indicate the advance notice that they must give if they want to cancel the appointment. And if they fail to do so, the employee can be asked to sign a consent allowing the employer to make a deduction to their pay for the cancellation fee. Now, if an employee fails to attend a first appointment with an occupational health expert and gives a valid reason for doing so, even if there is a cancellation charge and they've signed a consent for you to make a deduction, I wouldn't do so because I don't think it's reasonable. But if they then fail to attend a second appointment for no valid reason, then I think if you've got that consent, you can make the deduction. By informing the employee and getting their consent to make a deduction for cancellation fees, it is a good deterrent for them not to miss an appointment. So that's something to bear in mind. But ultimately, if an employee fails to attend an appointment or they refuse to go and see occupational health, it doesn't mean you're having to stand still and do nothing. You simply inform the employee that if they are not going to partake in this and they're not going to see occupational health, then decisions relating to their future employment or any formal processes that you may need to commence will have to be taken and undertaken without the employee or without the assistance of medical advice from an occupational health expert. And that may impact on them negatively. So what you're doing is you're telling the employee that the consequence is that you will still proceed to have to deal with future issues relating to their employment, whether that's attendance or performance, but without the assistance of medical advice. Now, an employee may say to you, well, I'm not going to attend occupational health, but I will allow you to get a report from my GP. And I've had situations like that because obviously they think that the GP's on their side and they don't want to they feel probably anxious to see somebody else. If it's the latter, then we need to work with the anxious employee and inform them that an occupational health expert is an expert. They deal with these things on a day-to-day basis. They will see employees with mental health issues on a day-to-day basis. If the employee wishes to do so, they can be accompanied by a friend or a relative to that appointment to try and make it as comfortable as possible for them. If they're still unwilling to attend and still pushing for a report from a GP, then really I suppose it's better than nothing. And you will or you could ask a GP to confirm whether or not the employee is fit enough to attend an appointment with an occupational health expert, or try and point the GP to try and persuade the employee to see occupational health. This is all timely, it's all difficult and can be frustrating. But the key is to try and get medical advice.
And Keeley, what if the occupational health advice directly conflicts with the GP advice? Should we be going with the occupational health, or do we have a duty to challenge it further?
I think you do. I mean, I think you have to challenge it with the occupational health expert. So in that situation, what I would do is I would send the GP's report to the occupational health expert. Okay, it's going to incur you more cost, but ultimately send it to the occupational health expert, highlight the conflict between the two reports and ask them for their further view on it. If there's still a conflict, then I think it's a case of what's reasonable for the employer to do in the circumstances. And I think it depends on, the gravity of the conflict and whether that's on a diagnosis or it's difficult without knowing what the precise conflict is. But I would firstly put it to the occupational health expert and ask them to comment directly on the conflict that has arisen.
Okay, thank you.
So returning then to a situation where an employee actually will attend an occupational health appointment. So we've managed to persuade them to go. So the letter will be sent from the occupational health report provider to the employee, informing them of the date and the time for the meeting. They will also send the necessary consents for the employee to sign, and they will also inform the employee of their rights. Now, their rights are twofold. So obviously, one being under the data protection legislation, GDPR, that they have to consent for medical information to be provided. And secondly, the one is if the occupational health expert needs to access the employee's GP records, then they will need the relevant consent under the Access to Medical Reports Act to do that. But that should be sorted out by your occupational health expert provider. As I say, they will send out the date and time for the meeting. Also, what they will tell the employee is that the employee has the right to read the report when it is drafted first and make any necessary amendments that they feel fit and wish to make to the report. So, and that is their right. So you may have a situation where it's taken quite a long time to get the report, then it goes to the employee, it sits with the employee for a while they make amendments to it. It goes back to the occupational health expert, and eventually it comes to you. So it can take a bit of time. You may already have your own occupational health providers. There are 3 suggested on this slide. I've used more recently Forge Health, which is Leicester based. They're doing virtual appointments. Well, they all are, obviously. So even though they are Leicester based, they will provide national support at the moment. Medigold operates through a network of national occupational health providers, and so does the latter one. You can expect the cost of a virtual consultation and report to be around £300 to £500 plus VAT. It will cost more than that if you are asking the occupational health expert to review medical records of the employee's GP or treating consultant.
Great. And what do you think we'd expect to see on an occupational health report?
Okay, so what the content of an occupational health report should be structured in a way whereby the occupational health expert initially provides their opinion about whether or not the employee or the employee's impairment satisfies the definition of a disability. And we've looked at that definition of disability. So they will provide their view. Now, their view or opinion. Now, their opinion should not be taken as the reality of the situation or factually correct, because it will be for the employment tribunal to determine whether or not the particular employee was suffering with a disability as defined by the Equality Act at the relevant time. So, although it is extremely helpful to get an expert's view as to whether or not the employee satisfies the definition of disability, there have been situations whereby that view has subsequently been determined as incorrect or factually determined as different at an employment tribunal hearing. So please be cautious about it. But saying that, it is extremely helpful to get an expert's view on these matters. And of course, the expert will have been discussing with the employee at the meeting that they have with them about the impact of their impairment on day-to-day activities. They will know the definition of disability, and they will be able to provide that information to you in the report. Also in the report, it will hopefully answer all of your questions. I'm not saying you know all your questions will be answered, and you will be you know, everything will be covered, but hopefully at least some of your questions will be answered. The experts may have provided their view on how long a long-term sickness absence may, the employee may be on long-term sickness absence. They may be able to provide a view about an employee's return to health to enable them to have a sustained period of attendance level. And they may be able to provide a view about whether or not performance that's impacted by a potential disability will improve, and in what sort of time scale. So hopefully it will give you some assistance in determining those issues. And it will, far more often than not, provide you with a list of temporary or permanent adjustments that could be made to an employee's work duties, environment, work pattern, or situation to assist the employee. And that is key, really. That's what we're looking for, because the occupational health expert will understand the discrimination legislation. They will understand what a reasonable adjustment is, and they will be able to provide us with adjustments that they recommend could be made. Now, it is then for us to consider those adjustments, because they may not be reasonable for us to implement. But if they are detailed in the report, we can then consider those with the employee and investigate whether or not they are reasonable for us to make in the circumstances. Okay, I think I'm ready for the next question.
Yeah. Okay, so Keeley, what should an employer take on receipt of report of an occupational health expert?
Yeah, so what steps should the employer be taking? So that's the report. We've got the report. And what do we do now? So we need to obviously thoroughly read it. We need to determine whether or not the expert's view is that the employee is probably or potentially suffering with a disability as defined. If they are, then we're live to having to make reasonable adjustments if they can be made. We need to investigate that list of adjustments. That's the first thing, really, that we need to do. Are they reasonable for us to implement in the circumstances? So as I say, there could be a long list of suggested or recommended adjustments to be made that the expert has detailed in the report. But it's for us then to investigate whether they are reasonable in the circumstances for us to implement. The next thing for us to do then is to arrange a meeting with the employee to discuss the report with them and advise them on the next course of action, whether that be those adjustments that we determine to be reasonable and when they will be implemented, or not, as the case may be. Again, that meeting should be confirmed in writing. So what was discussed at the meeting should be confirmed in writing, including any advice or any agreed actions that we discussed with the employee.
Fabulous. So do all or any adjustments that are recommended by the occupational health expert need to be implemented?
Yeah, so the category of disability discrimination that's relevant here is called the duty to make reasonable adjustments, and we've all heard of it. The definition is as detailed on the slide. So it's where a provision, criterion or practice applied by the employer puts a disabled person at a substantial disadvantage in comparison with those who are not disabled. Then the employer must take such steps as is reasonable to take to avoid that disadvantage. So we need to look at what is preventing the employee from performing or from attending or meeting the criteria, and that's putting them at a disadvantage. And we need to make adjustments, reasonable adjustments to that, whether it be a policy or a practice or a pattern or whatever it is. We need to make adjustments to that to ensure that the employee is not placed at that disadvantage, to remove the disadvantage. And as I say, I keep harping on, but it's what's reasonable in the circumstances for us to do. So therefore, if there are only adjustments that can be made that are determined to be unreasonable in the circumstances, an employer will not be committing an act of discrimination if they do not implement them, as long as they have investigated the adjustment, determined that they are reasonably determined that they are unreasonable to make in the circumstances, then they will not be discriminating against the employee.
Okay, lovely.
So the occupational health expert, as we said, may provide this list for us to consider and investigate. It may be adjustments to the working environment, it may be adjustments to the pattern, working hours, and then it's for us to explore those and investigate those. So these are some examples then of reasonable adjustments for an employee who is suffering with anxiety and depression, disabilities. So it might be that if the employee is on long-term sick, that it's a phased return to work. And we've probably seen this a number of times in the workplace where the GP or the occupational health expert says, yeah, we think they can return to work in a month's time, or at the end of the current fit note, but it will be on a phased return. So it might be 3 days a week, increasing to 4 days a week, increasing to 5 days a week over a period, I don't know, of 4 weeks, something like that. The adjustment might be a later commencement of work time to assist the employee in giving them a longer period of time to get ready for work, or to sleep in slightly later if they're suffering getting to sleep or having difficulties getting to sleep. That might be a reasonable adjustment to make in the circumstances. It might be a reduction in work generally, being provided as a reasonable adjustment, either on a temporary or a permanent basis. It may be giving the employee a reduced number of tasks to work on at any one time because the employee is finding it difficult to multitask. It might be giving the employee permission to take 5 minutes away from the screen during each hour, or at the end of each hour of working, that isn't then part of a performance process or structured as a performance process, or just gives them 5 minutes to go away from the screen, and they're not being assessed within that time period if they're having to do timesheets, for example. Providing an employee with printing equipment to reduce screen reading, giving the employee a lower production or performance level than other employees in their team, or giving an employee another role or different work to conduct. It might be that you move the employee to another work area or under another manager if the personnel that the employee is working with at the time are exacerbating the situation. It might be working with the employee to structure the employee's working day in a way that takes into account any anxiety conditions. So blocking out periods of the day where the employee is just focusing on emails or just focusing on document work, for example, and working with them to use their out of office on the time periods they're not going to be accessing their emails. It might be holding review or update meetings with the employee on a weekly basis if these aren't held generally. It might be giving the employee more rest time, either by giving them unpaid leave at certain intervals or increasing their breaks during the working day. Also allowing the employee to attend work rather than work remotely for a set day or for set hours a week to assist their mental well-being. And I've seen this happening. So generally, obviously, the guidance is to work from home if possible, but if somebody is suffering from a mental health disability and they are saying it would really help me if I can come into the office on a day a week or 3 hours a week, and that has been granted as a reasonable adjustment. Also allowing an employee to be accompanied at a formal or informal meeting by a friend or relative where the employer's procedure generally doesn't allow that. Also communicating decisions face to face where it is usual in the employer's business to simply communicate decisions in writing. So some of these you may think, oh, is that a reasonable adjustment? So there can be really small things that make actually a big difference and will still amount to a reasonable adjustment. So you're making adjustments to the usual practices within your business to assist the employee. And as I've said, whether the suggested adjustments are reasonable ones to make in the circumstance is really down to the employer. And it's down to the employer to investigate what has been recommended, and then to provide reasons if they are saying that the adjustments that are being recommended are not reasonable in the circumstances, and to keep that paper trail in case an employee brings a claim. So what are the consequences then of not implementing reasonable adjustments? So if the employee is suffering with a disability and we fail to provide reasonable adjustments in the circumstances, usually the first port of call will be for the employee to bring a grievance about the situation. If that grievance can't be resolved, then they will then log their complaint through ACAS early conciliation process, and then after that they may bring a claim in the employment tribunal. If they succeed in that claim, then they will be awarded the financial loss that results from the failure to make the reasonable adjustment or adjustments, and they will be awarded an injury to feelings award. That's uncapped, both of those are uncapped, but the injury to feelings award is considered in 3 bands. The first band, the lower band £900 to £9,000, middle band £9,000 to £27,000, and the highest band £27,000 to £45,000. The level of the award, the injury to feelings award, depends on the gravity of the discrimination suffered, the effect on the employee. Has it created, for example, a psychiatric injury or worsened their pre-existing disability, and the time period for which it has been suffered. So all those things go into determining the level of the award. But what if no reasonable adjustments actually are being recommended by the occupational health expert or can be determined by us? So there are situations like this. They're usually situations where an employee has or is on long-term sickness absence. They go off to see occupational health. The occupational health expert returns to us, provides their report, and states that they can't foresee a possible return to work date, and there are no reasonable adjustments that can be made, or no adjustments that can be made to facilitate a return to work in the foreseeable future. The occupational health expert may indicate that they would like to review the situation in, say, 3 months' time. And if they do that, then I would recommend you wait for that 3-month period or whatever it is, and ask the occupational health expert to review the situation. However, ultimately, if the occupational health expert is saying that they can't foresee a date of return, and you are unable to identify any reasonable adjustments to facilitate that, then it's really a case of how long is it reasonable for an employer to wait before they engage in a dismissal process. And that is really a factually specific situation, because it depends on the employee's job, how or what impact their absence is having on their colleagues or the team in general. Can the employer cover the job? What cost is that is the employer being put to cover the work? And a whole host of matters need to be considered to determine what is a reasonable length of time for the employer to wait in the circumstances. If there is a possibility of ill health retirement under the pension scheme that the employee benefits from, that is certainly something to consider in these situations, and it would be unlawful not to do so. But if that isn't a consideration, then ultimately the employer will simply have to conduct a final investigation as to whether or not there are any reasonable adjustments that will facilitate the employee's return. If there aren't any, then it will proceed to invite the employee to a formal hearing. In that letter, inform the employee that the outcome of the hearing, if no reasonable adjustments can be identified or a foreseeable return date identified, then the outcome could be their dismissal on notice. Proceed to hold the formal capability hearing, at which the employee can be accompanied by a work colleague or trade union representative. And I would urge you to consider making a reasonable adjustment to that, to allow the employee to be accompanied by a friend or relative to offer them more support. And then ultimately to make your decision, and that decision should potentially, in the circumstances, be communicated face-to-face or via a virtual meeting in the present day, with the employee being adequately supported. So if it is a dismissal on notice, then because of the health condition of anxiety or depression, then I would certainly suggest that somebody is with the employee when you communicate a dismissal to them as a reasonable adjustment. So it's a tricky one, and but unfortunately it does happen. So
Keeley, before we go on to the next question, there's a question that's been sent in. If an employer has already provided reasonable adjustments, but these cannot be sustained as the manager in question is now being affected due to them taking on the additional workload, how would you advise the work is passed back to the employee in question, or what should they do?
Yeah, I mean, I think you need to look at we explore. You've got to explore options, haven't you? So if the current manager who's taken on the work is being affected by the situation, too much work, then we need to look at whether or not there's anybody else who can conduct that work. Is there can we recruit a temporary member of staff to take on that work? All those options need to be explored and a paper trail conducted. If ultimately nobody can take on the work and it wouldn't be cost effective, or it's not it's determined unreasonable to recruit a temporary cover, then we need to engage in a process with a particular employee about gradually increasing their workload to a level that the employer requires them to conduct, and making as many reasonable adjustments in that regard. But you know, it's tricky, isn't it? Because we've taken the work away from them and now we're wanting them to conduct it again. So get some medical evidence. If the medical evidence is suggesting that the employee cannot take on that additional work, then you may end up having to go through a dismissal process, because it all comes back to what reasonable adjustments can you make in the circumstances. So the circumstances have changed. Ultimately, you need the employee to take on more work again. Hopefully you can do that in a gradual way that takes into account their potential disability. But if the employee is unable to take on that work, even over a gradual period of time, then the whole situation becomes unsustainable. And so ultimately it could end up in a dismissal situation, but it's a process to have to go through. So it's not something that can be done quickly. I think it's a gradual thing. And as I say, I think the medical evidence needs to be obtained initially, then discussion with the particular employee to increase their workload over a gradual period of time to take into account their potential disability and in a way that hopefully they can cope with that. And if they fall down or if they're unable to do that, then potentially it's a dismissal process.
Okay, great. Similar question then. If there's no improvement in an employee's attendance level following reasonable adjustments being made, what can the employer do?
Yeah, so we've considered a situation whereby there's no reasonable adjustments that can be made, usually in a situation where an employee is on long-term sickness absence. So this question relates to a situation where an employee has a high level of intermittent sickness absence. So what we need to do is we need to obtain the evidence from occupational health. We need to implement the reasonable adjustments in order to be able to improve the employees' working conditions to the extent that that then improves their attendance level. And then we need to have a very clear communication and discussion with the employee about the expectations in terms of their attendance going forwards. So reasonable adjustments will need to be made to the usual requirements of the employer in respect of their employees' attendance level. So if an employer uses a Bradford factor or similar method, and an employee reaches the trigger and is invited to a formal meeting and a warning is issued, it's that trigger that needs to be adjusted to cater for the employee's disability. So we need to adjust the requirements of a non-disabled employee's attendance level to cater for the disabled employee. And then we need to monitor the employee against that adjusted attendance level requirement. So we can still enter into an attendance management procedure, but in a formal warning procedure, but we need to make reasonable adjustments to that process and the trigger or the required level of attendance. So once we've had that discussion with the employee and informed them of the reasonable adjustments we're going to be implementing to assist them, and that unfortunately we're going to have to monitor their attendance level, but against adjusted attendance level requirements, we need to confirm that to the employee in writing, and then we need to monitor their attendance. If they fall down despite the reasonable adjustments that have been made, both to the attendance level requirement as well as their working conditions pattern, etc., then they will need to be invited to a formal meeting at which they can be accompanied, and the potential outcome then will be a first written warning, which they can appeal. And then the procedure continues. Next formal performance or disciplinary or capability hearing, they are issued with a final written warning, which they can appeal. Then the procedure continues again, and the outcome of that final capability or performance or disciplinary meeting will be dismissal on notice, which they can appeal. Reasonable adjustments being made, as I say, to the attendance level requirements as well as the procedure and process in general.
So what if there's no improvement in employees' performance or production levels following reasonable adjustments being made? What can an employer do then?
So it's very similar to dealing with attendance levels. Hopefully the occupational health expert will have provided us with a list of adjustments that we can then consider which are reasonable to implement to improve and assist us in improving the employees' performance and production levels, and generally reasonable adjustments to assist the disabled employee generally in the workplace. We will then have a discussion with the employee about the report, the recommendations, and any reasonable adjustments that we are able to implement. And we will inform them that unfortunately, because of the situation and the effect that their performance is having on colleagues, etc., it will need to be monitored over a period of time. We will need to discuss with the employee objectives and criteria that we wish them to meet over the monitoring period. And we will need to make reasonable adjustments to those objectives, aims, criteria in order to make them reasonably achievable by the disabled employee. So it's looking at the job description and the list of tasks, putting together the objectives and the criteria that we need the employee to meet, and making reasonable adjustments to those to cater for the employee's disability. We then go through the usual process of monitoring them against those aims and objectives. If they fall down, the employee is then invited to a formal capability performance disciplinary meeting at which they can be accompanied, first written warning issued. Then it continues, next formal hearing, they will be issued potentially then with a final written warning, and then the final hearing, dismissal on notice. Each warning, in respect of each warning, the employee will need to be given the right to appeal that warning, and of course they will need to be given the right to appeal the dismissal on notice. Now, I appreciate these situations when dealing with an anxious employee can, of course, increase anxiety and stress. And you will no doubt experience employees missing hearings or refusing to attend hearings, or not turning up and going on the sick, and these are all complications within an already difficult procedure dealing with difficult issues. So I appreciate that this textbook advice is not going to always be practically possible, but that is the procedure that we need to aim for in dealing with employees suffering with these conditions. It's all about making reasonable adjustments to an existing performance procedure.
Okay. So when can an employer lawfully dismiss an employee suffering with anxiety or depression that's got a high absenteeism level?
So we've done, yeah. So I think the main thing that we need to think about here is going through the right procedure, which I've already touched upon. So it's getting the occupational health advice. It's then investigating and implementing the reasonable adjustments that can be made. And then it's going through a procedure to deal with the absenteeism level. So we are informing the employee of the required level of attendance. We are making reasonable adjustments to that required level to take into account the employee's disability. And then we are conducting the usual monitoring and warning process, issuing warnings that then ultimately can lead to the employee's dismissal on notice.
Okay, Elaine's just asked a question. She said you referred to adjusted targets being reasonably achievable for the employee. What if what is reasonable to the employee is not reasonable to the organisation? So, for example, the adjusted attendance targets that we know the employee is unlikely to be able to stay within.
Yes, it's what's reasonable for the organisation. So there's bound to be a conflict between what the employee is saying is reasonable and what the employer is saying is reasonable. So it is for the employer to determine what is a reasonable level of attendance, taking into account the employee's disability, and it may not be achievable because of the employee's disability. But what the employer is doing is making reasonable adjustments to the level of attendance requirements. So if, for example, I mean, I've got a case example, which unfortunately we're not going to get to because of the time, but in a situation that I dealt with, and it'd probably be useful to send it out in paper format, the employee's attendance level was required to, well, generally employees were required to sustain a level of no more than 2 days absence per month. This employee, a reasonable adjustment to that target was made in respect to this employee, and the employer was able to tolerate an absence level of up to 4 days a month. So that's double what other employees' usual expected attendance level was. So it's then communicating that to the employee and saying, look, we've made a reasonable adjustment. We can't go any higher than that because of the impact it's going to have on colleagues. And already reasonable adjustments are being made potentially to this employee's level of productivity, which is already lower than their comparable colleagues. So that's another reasonable adjustment being made in respect to this particular employee. So that's as far as we can go. And of course, in the end, the employee was not able to sustain even that adjusted target level, which then ultimately would have led to his dismissal. So it's what the employer can reasonably tolerate. And of course, that's going to be different for different sized employers with different resources, different teams, different jobs. It's very factually specific.
Okay. Thanks, Keeley. So when can an employer lawfully dismiss an employee suffering with anxiety or depression with an unsatisfactory performance level?
So again, we're having to make reasonable adjustments to performance criteria and objectives. So in the usual way that we manage a performance issue with an employee, in respect of a disabled employee, we are formulating those required objectives, criteria, and we are making reasonable adjustments to those and the timescale to achieve those to cater for the employee's disability, taking into account the medical evidence that we've obtained. So, and then it's going through the usual performance management process, warnings, formal warnings, and then ultimately dismissal on notice. And making reasonable adjustments to that procedure as well, supporting the employee and giving them assistance, reasonable assistance as and when we can during that process, allowing them to be accompanied at meetings by a friend perhaps or a colleague, a friend or a relative, rather than simply a trade union representative or work colleague. So it's providing them, as I say, with those reasonable adjustments, both in respect of the performance targets that we need them to meet, but also in respect of the performance management procedure itself.
Okay, I've just had another question that's come in. So should there be a repeat referral during a capability disciplinary process, which can take, that process can take 18 months? If so, what is expected from the employer?
Yeah, so I agree. I mean, these procedures can take a long time. If you have got a report that is 18 months old, and you are reaching the final stage of a capability process 12 months down the line, then before dismissal, I would certainly suggest that you have a review of the medical evidence or a review opinion, an up-to-date opinion from the occupational health expert.
Okay, great, thank you. So what are the possible consequences of dismissing an employee with anxiety or depression?
So the possible consequences are if the employee has a disability, then if we haven't made reasonable adjustments, the employee can bring a claim for disability discrimination. And they will be arguing potentially that their dismissal has been because of their performance or absenteeism level, and because those matters arise from their disability, the act of dismissal is an act of discrimination. That category of discrimination can be justified, and so again it comes down to, have we followed a fair procedure, have we obtained necessary medical evidence and opinion, and have we done all that is reasonable before dismissing the employee. The other claim under the head of disability discrimination an employee can bring is failure to provide reasonable adjustments. Again, that's what we've already considered. So, where an employer has failed to make reasonable adjustments in the workplace, or in respect of the employee's working pattern, environment, job description, and an employee can bring then a claim for disability discrimination on that basis. We've already considered the compensation levels that apply to a successful claim. So it's the financial loss that flows from the discriminatory act, as well as the injury to feelings award. In addition, if the employee has been employed for 2 years or more, they can bring a claim for unfair dismissal. And this would be on the basis of an unfair procedure being adopted by the employer. So hence the reason why I've gone through the procedure in quite a bit of detail, because if that procedure isn't followed, or up-to-date medical evidence isn't obtained, then that could open the employer up to a successful claim for unfair dismissal. Compensation is a basic award, exactly the same as a statutory redundancy payment, and a compensatory award, loss of net earnings and benefits for a reasonable period, capped at 12 months gross pay, and it's gone up to £89,493, so the lesser of those two.
Okay, so when would it be appropriate to engage in a protected conversation with an employee suffering with anxiety and/or depression?
Okay, so a protected conversation is very similar to a without prejudice discussion. So I'm sure most of you will have heard of the protected conversation under Section 111A of the Employment Rights Act. So this is a conversation with an employee that should not be referred to in any future employment tribunal hearing when liability is being considered. It is a means to discuss with an employee and agree an exit with an employee on agreed terms. It is a tricky thing to do in respect of an employee who is suffering with a disability, because there may be a future argument that the employer is acting in a discriminatory manner by entering into a protected conversation, and therefore it isn't truly protected. So caution has to be applied when engaging with an employee about exit discussions. Usually an employer will commence a formal process, and during that process will hold a meeting with an employee and then confirm that in writing, indicating to the employee that the present formal process could result in the employee's dismissal. But there is another option for the employee to consider, which is a protected conversation, an agreed exit on agreed terms, and the employer puts forward a financial offer in order to prevent the employee then from bringing any future claim against it. If the employee wishes to engage in a protected conversation, and it's entirely up to them, they don't have to, they can then they will then need to take independent legal advice, and the matter will need to be dealt with via a settlement agreement detailing the terms of the exit and the financial sum that's being accepted by the employee to prevent them from bringing a claim.
Okay, great. I was going to ask, is there a case study or practical example that can be considered in respect of dealing with an employee suffering with anxiety or depression with attendance or performance issues?
There is, and it's a good one actually, but it's a lengthy one. So what we could do, Eloise, if you're happy with this, is we could record it separately, and then you could then send it out to everyone.
Absolutely.
I think it would be helpful to go through a practical example.
Absolutely. Yeah, we can organise.
If you're happy with that.
Yeah, no problem. Or final question then that we've had in, what can an employer do now to deal with potential performance or attendance issues attributed to anxiety and depression as lockdown eases and employees begin to return to office working?
Yeah, I mean, it's key, isn't it? Because As things start to open up, as the advice changes, whereby we're requiring employees to come back into the office, we probably need to get on top of these mental health issues. So we discussed in the last HRHuddle about employers having to consider, or it's worth them considering now, what working pattern they want to implement, whether that be a hybrid model, working some days from home, some days in the office, or whether it's a full office working again, or whether it's a continuation of home working. Alongside that, I think an employer really needs to think about communications to employees about requirements in terms of working hours. Is it 9 to 5 with a stipulated lunch break of to be taken between 1 and 2? Is it different to that? Is it a part-time working from the office and home, in which case then if they're continuing to work from home, the requirements around that. Is it therefore timesheets that are required if they are working from home rather than in the office? So it's all those, and it also it's stipulating the aims and objectives in terms of performance, and that's if the employee continues to work from home or if they return to the office. If that can be clearly communicated, then the employee can be reminded of those things as the employer communicates the new or changed working pattern, and then I think it's worth doing. And then that communication can then be referred to if there are issues that arise going forwards. If an employee is refusing to return to work because of a condition of anxiety or depression, then it's, as we discussed before, it's trying to deal with those concerns raised by the employee. It's obtaining occupational health advice if we feel it's necessary, and it's working with the employee to try and get them back into the workplace. Ultimately, if reasonable adjustments have been made and the employer has done all that it can to facilitate the employee's return to work, then it's a disciplinary process that will need to be entered into. And it's also those things that I'm sure everybody has already been doing, which is to ensure that training is provided about mental health. Sorry. Yes, training is provided about mental health, and staff may be given access to trained individuals, trained managers, to raise concerns with them if they feel uncomfortable with raising it directly with management.
Okay, fabulous. Thank you. Thank you, Keeley. That was a really informative session.
Sorry about that at the end.
Loving the telephone call and your husband popping in.
And the dog.
And the dog. Well, it's all right. It's all family friendly. So thank you everybody for joining us. I hope you've enjoyed the afternoon. Keeley, it's great to get such thorough advice from you. Like I've said, a recording will be sent out early next week with Keeley's contact details, and I know she'll be happy to talk with anybody that's got any additional questions. If you need any specific help, obviously feel free to contact her. So the next session that we're running for the HRHuddle, the next live webinar, is on Wednesday, the 18th of August, and it's with Julie Dennis, who's going to talk about menopause in the workplace, which is another great topic, and I was going to say another hot topic, but yeah, that'd be another pun. So join us for that. The invites will be sent out shortly. But thank you again, Keeley. Thank you for joining us, and we will see you all very soon.
Thank you.